author, columnist, editor-in-chief of LibertyNation.com, talk show host, and conservative policy advocate.
We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
Hello and welcome to Liberty Nation Radio, heard coast to coast on the Radio America Network from our flagship station in the nation's capital, WWRC in Washington, D.C. I'm your host, Mark Angelides. On today's special edition, we are talking the big finale at the Supreme Court. It's going to be quite the show. Please do remember, Liberty Nation Radio is sponsored by LibertyNation.com. You can access podcasts, breaking news, analysis, and a range of biting and brilliant shows to whet your appetite for freedom and your fondness for the great American Constitution. And welcome back to Liberty Nation Radio, heard coast to coast on the Radio America Network. I'm your host, Mark Angelides. On today's special Supreme Court edition, we are talking with Liberty Nation's legal affairs editor, Mr. Scott D. Cosenza, Esquire. Thanks for being here, Scott.
Thank you, Mark.
So, Scott, this was one of the most epic endings to a Supreme Court session that we've witnessed in recent years. It's almost as though they knew that pretty much every newsman in the business was hanging out for the big cases, like half a dozen really big cases. And they thought, let's just drop them all on the very last day.
Mark, I have to tell you, it's not all about you.
It is.
The few times a year when you general news dogs come and ghettoize yourself and hang out at the court for the latest and greatest updates. Some of us are there day in and day out looking for these scraps that they throw out. Well, the thing that you have to realize is, so that I'm trying to remember what the case count was that they waited until the Friday at the last Friday in June, which is when they like to kind of clear their.
There were six cases, I believe, on that one.
Okay. Yeah. And what you have to remember is, for every case where there is something other than one opinion written, so if there's a concurrence or a dissent or a minority opinion dissenting that's an extra dissent, all those things have to be buttoned up to the letter before they're published. So if one person has one paragraph they're working on, or it could even be as simple as like waiting for a citation from some clerk, although clerk's probably not going to hold up the whole court for a couple days, but there can be very, very much administrative and housekeeping things. And by the way, something I noticed when I circled back from this last batch of cases is there were 2 corrections issued. So 2 things actually went out prematurely. Now, the corrections I don't think had any substantive value of any import, but the court does like to get things right. And as you can see, they still didn't even manage to do that because of, I think, rushing out the door to get things ready. And of course, I'll just add this in a rush, the protester type stuff. If you have a contested case that's going to generate a lot of public interest right on the way out of town, you file it and then you don't have to worry about them trying to shut down the streets around the,
well, it gets people excited for the next season, right? The big grand finale as the courts become Kardashianized. Kardashianized courts. I think I'm going to use that in an article, the Kardashianized courts. But there was some really strong language that I do want to get into, specifically from Justice Amy Coney Barrett to her fellow justice. In one of the opinions, and we are going to get into that. But there are 3 things, Scott, that I really want to use your amazing legal brain to drill down on during this show today. And the first one is actually a case that wasn't really a case at all. It was I guess it was asking for relief from the relief, and this was the universal injunctions. Now, for me,
or titled in many places, Birthright Citizenship case, which it turned out not to actually be. So
we are going to get to the Birthright Citizenship, but yes, that was the one. So it was Trump v. CASA, C-A-S-A, and the justices there, the majority opinion 6-3, they wrote that. It was
Amy Coney Barrett
wrote, and then the 5 others signed.
Everyone else signed on. Yeah,
not everyone else. Eh?
No, every one of the. Well, actually, let's fine tune that just quickly and say that, and we'll just say that Trump signed an executive order mandating that birthright citizenship was extinguished in this country, which is to say the notion of if you were born here, you are automatically a citizen of the United States is over because of people who come here illegally or legally, but also are not
citizens of the United States,
or not even residents. Like, in other words, you can just be on vacation from Canada and have a kid, and your kid's a Canadian citizen,
an American citizen, even.
Oh yeah, right.
Yeah, because nobody would want to do that to their child, would they?
And so Trump signs his executive order. There's a nationwide injunction issued by I can't remember if it was a Biden judge. I think it was a Biden. Anyway, it doesn't matter. A democratically appointed judge, sort of a typical thing that so many Trump supporters are frustrated with, stymied by one district court judge in one of the places where there is such a thing around the country, and then the entire country can't be subject to the administration's goals because of that. Well, the court took the case not to resolve whether or not the order about it birthright citizenship was legal.
We're keeping that in the radio.
About whether or not it was the universal injunction was appropriate. And so Amy Coney Barrett writes the decision, which all 5 other justices in the majority sign on to, and they don't reserve any of their agreement, which justices often do. So yes, in a longer opinion, you'll often see it numbered via parts, and then a justice will say, I concur with parts 1 through 3, skipping part 4, and then concur with 5. And then that might be how they do it. But in this instance, and it's going to be important when we lay out the language that she used, well, every single judge, including the Chief Justice of the United States of America, Justice Roberts, signed on to this part of the opinion. So I just wanted to make sure people had that background before they got the meat.
So let's talk before we move on to what Justice Barrett wrote. I want to talk more about how important this is, that universal injunctions are now effectively blocked, right? So this doesn't mean that there isn't any remedy. I believe it had a carve out for if it requires multiple people to be impacted, or multiple people will be impacted by it. They can always go with for example, a class action.
Well, let me just unpack that for a second, rather than you.
Sure.
Let's have the lawyers summarize the actual. So they're not banned. Sure. Universal injunctions are not prohibited. What the Supreme Court has done is kind of level set the district judges and said, for you to basically enact a nationwide prohibition, there has to be kind of an extraordinary series of events, which is to say that the person in front of you, the litigant in front of you, who has asked for relief from some illegal act, which is what a court case is. They're behaving illegally, Your Honor, make them stop, right? That's the nuts and bolts of it. Only if the nationwide injunction was required to give what's called complete relief to that person would they be able to issue the nationwide injunction. It doesn't make it void or never going to happen, but it dials back by like 100 to 1, maybe, you know, what we might maybe expect to see. And the reason, and you're right about that, they didn't add a new rule or there's no new information about class action lawsuits. So all the justices have said is go through and get a class action started if that's what you really want. The problem with that is that it takes a lot more effort on the advocate side to establish a class and to get class action status, which is why it's much easier, and they don't want to do it, to just apply for, a nationwide injunction. And it's a lot easier for the judges too. They don't have to go through the work of sorting through the class application. That in and of itself is a bunch of work that a judge probably doesn't want to do. So,
well, of course, it's so much easier just to not do work and then just impact the entire country, because that's what judges are for, right? We're going to be back with Scott, continuing this conversation after this short break. Don't go anywhere. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
Andrew back on Liberty Nation Radio, heard coast to coast on the Radio America Network. I remain your host, Mark Angelides, and we're continuing our conversation on the Supreme Court and universal injunctions with Liberty Nation's legal affairs editor, Scott Cassenda. Scott, speaking of these universal injunctions, so are they fairly common? Were they fairly common prior to the Supreme Court ruling?
Well, I'll tell you what, I've got in front of me some numbers just to give you a sense of how this has affected Trump, and you were making the point of why it's such a big deal. George Bush, was subject to 6 total injunctions in his 4-year presidency. President Obama was subject to 12 in his 8 years of being president. And by the way, the numbers I'm reading you are published from the Harvard Law Review from 2024, before Donald Trump resumed the presidency in his second term. So these are first term only numbers and compiled by an organ that is, might say at best, skeptical of Trump rather than, if not outright hostile to him, right? So in any case, 6 for Bush, 12 for Obama. Donald Trump, 4-year presidency, 64 nationwide injunctions. And Biden had 14 in his single term in office. So
now, I'm going to play devil's advocate quickly here, Scott. Some people would argue, not me, but some people would argue that, well, that's because he broke the law more. Does that argument hold water, Counselor?
So the injunction isn't about whether somebody broke the law. And just to be clear, like I'm approaching it from the actual literal kind of application of the law. And what the ruling is that what those judges were ruling on was that the Trump administration was likely to lose, and that therefore they were able to grant those injunctions unguided by this notion that the Supreme Court just enforced with the CASA ruling, that they shouldn't do that at all, basically. It just kind of crept into the law where they were doing it more and more. And the Supreme Court had kind of beaten around the bush about it, but they never really got down to brass tacks and addressed the question directly, which is why this is such a major case and will change so much. I would say to you, for your devil's advocate question, that read the Supreme Court opinion and you'll see why I think that's a bad idea.
No, I think so. I mean, my thoughts on that specifically are that when Donald Trump won the election in 2024, November 2024, Democrats said that leading Democrat voices were saying that we're going to take him to court, we're going to sue him, we're going to hold him to account through the law courts. And they fundraised on it. And there are multiple organizations that are linked to the Democratic Party whose sole purpose is to sue Donald Trump and the Trump administration. So I would imagine
to great effect, by the way.
To great effect,
they've done
absolutely.
Very well with their campaign. I mean, you look at that 64 universal injunctions, that is quite a success if you're trying to stymie an administration's implementation of their goals.
So how many of these were filed in Alabama, by the way?
I don't know. But actually, if you think, really, Alabama is not the kind of place where you get this kind of treatment. You get it from mostly a northeastern or West Coast judge.
Yes.
Just because that's where the more radical ones seem to be appointed to, and then to the appellate courts growing from there, by the way.
So it really was a case of shopping around for a judge that's most likely to, or it appears to be a case of shopping around for a judge that's most likely to be favorable.
No, I think position. You file in a district where you get you have a odds-on better chance, but no, judge shopping is a bit too risky. One thing you could say is, so if we think about how these cases are, previous to the new landmark ruling that the Supreme Court sent down this past Friday in June, how it would work is the case goes before a district court judge. That judge, let's say they do issue a nationwide injunction, then it goes to the appellate courts for them to look at before it might go to the Supreme Court. Well, you may choose which circuit you bring the case in, just because you want to get a favorable ruling at the circuit court level, the Circuit Court of Appeal level. But even then, if you just get how this is a bit inside baseball, but if we really want to talk about the mechanics of it, you have to get into it. Those appellate courts often assign a 3-judge panel to look at these different cases, and they don't do it with. It's not like, oh, hey, you like politics, right, Mark? You can go look at this case. No, it's all very much randomized, and who gets these cases is not selected based on the president that nominated the the person for their appointment or anything like that. And so you can game it a little bit maybe, but boy, of all the things to try to control outcomes for, it seems like you're better off spending a little more time on your brief maybe than trying to get a favorable particular judge.
Okay, so from here on out, judges will be able to, district court judges will be able to grant the relief that they see fit for the individual. The lawyers in the case will be able to seek to create a class action with a number of litigants. But what happens if somebody does order a universal injunction? How does that get stopped?
Well, we can just say,
is there a time?
We can just say when, I think, instead of what happens.
Yeah.
Because at some point it's going to happen, and it'll go. Well, what happens is when that case then goes before the Court of Appeals, which it almost certainly will.
Yeah.
The Court of Appeals will now have this Supreme Court guidance to look at, and it'll be, instead of I don't know if rubber stamp is exactly the word I want to use to describe how the Courts of Appeals has been handling these things, but without much of a scrutiny that really examines, like, is this absolutely required to gain the relief that for these parties? So basically what it does is it creates another stopgap for the administration to not have to comport with that universal injunction and have it lifted. And I expect we'll see that happen with most of any that do get through, which is that the appeals courts will look at it and say, no, you didn't do a good enough job tailoring the remedy to the specific parties in front of you, which doesn't require that, and either instruct them to work harder to do it again, or to enact their own order that, to their mind, tailors an order, to the parties in front of the court without a nationwide injunction. And then it also, Mark, will go one more bite at the apple. Then the Supreme Court has the capability, without the full case briefing, of smiting down that district court judge. So, for instance, appeals, they call it the emergency docket. It's rarely an emergency, with the exception of some death penalty cases. But what happens is, when there's a case that comes out of, let's call it the Fourth Circuit Court of Appeals, which is where I'm talking to you from now, and it comes out of the Fourth Circuit, well, if the litigants don't want to wait for the Supreme Court to look at their case and rule on it in a timely fashion, they may apply for urgent review, in which case one particular justice is assigned to each of the circuits. I forget I should know this cold, and I'm sorry I don't. I should know who the Fourth Circuit judge is, but in any case, they will look at it and they will say, okay, if it's an easy kind of pitch for them to hit, they'll just say, this is the rule, do it this way. If it's a more contentious issue, they'll sometimes refer it to the whole court. But what I expect to see is more of those justices then saying, no, this does not pass muster for a universal injunction. So basically, at every step now, where there had been maybe a veil to pass through or some rice paper in terms of legal resistance, once the district court judge gave that universal injunction, now it's the opposite of that. Now it's a brick wall in front of them that they're going to have to keep going over.
We're going to be talking about that brick wall made by Justice Amy Coney Barrett after this short break. Don't go anywhere. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And you're back on Liberty Nation Radio. I remain your host, Mark Angelides. We're continuing our conversation with Liberty Nation's legal affairs editor, Scott Cosenza. Scott, so we've been talking about the universal injunctions in Trump v. CASA, and we've discussed what ramifications it has. We've discussed how court cases will proceed now from district levels. But what I really want to get into is the actual opinion that came down on this, and how it was so out of the ordinary in terms of its language. Care to enlighten us?
Well, yes, and it's a reaction piece. So you can't understand the language or really, I think, discuss it meaningfully without discussing what it was reacting to, which is Justice Ketanji Brown Jackson wrote in dissent. She didn't write the court's dissent. How it works is the Chief Justice after getting a vote tally on these cases, assigns a majority opinion to one of the justices in the majority, and for the dissent in the dissent, and then other justices can write separately if they choose to. But one of the reasons why that gives him a lot of power is, for instance, before we just get to answering your question, a chief justice might give a more moderate voice, like Amy Coney Barrett, a case in this instance because they want the most maximum level of agreement. And if they gave it to a firebrand, then maybe they won't get a sign on to get as many justices as possible for a majority opinion, which does give that opinion power. That this is a 6-3 opinion gives it a little more power in legal circles than if it was a 5-4. So Justice Ketanji Brown Jackson took her pen out after saying that she agreed with everything. I think it was Justice Kagan wrote in the majority proper, or excuse me, the dissent proper. But she took her pen out literally just to say how awful this reasoning was, and how basically it was. And I'm not being hyperbolic here. It would. There's a strong case to be made that it would lead to the end of the republic. That's what Ketanji Brown Jackson's dissent said, and it denigrated the majority opinion and the effort to explain their reasoning and the reasoning itself. It was really an insult from her to them, like just a high level. By the way, it didn't get schoolyardish, I don't think, at least not much, but it was a very much insulting, denigrating opinion. It didn't respect their thoughts or their judgments. It just hit them kind of below the belt with it. And so that's what Amy Coney Barrett was reacting to. And boy, she did react to it.
Before you come into the reaction here, which really is quite fiery, I felt that, and I'm just a layman in this, but I felt that the language of Justice Jackson's piece, it was a little social media-ish, because she wrote something period, spelling out the word period like you see on social media. I thought that must be the first time that any justice has ever written that.
I think she's our youngest justice. She's certainly the newest addition to the court, and unfortunately, I think we're going to see more stuff like stuff like that.
I clap back against the majority opinion.
Oh, that's so hilarious that you said that. Yeah, exactly.
All right, so let's get to what Justice Amy Coney Barrett actually reacted to, how she reacted to Justice Jackson's.
One of the funniest kind of and biggest, deepest cuts, I think, was when she criticized Jackson for talking about how something was like legalese. And it's like, we're the Supreme Court. You can't say something's like, you're not going to pay attention. Oh, that's just legalese. Like a politician, a senator maybe could get away with that. Certainly a congressperson. But for a Supreme Court justice to kind of dismiss a thing as being, oh, that's inside baseball. Like, well, where is the place for the discussion of this inside baseball if if not
the house that Frederick Douglass built, right?
Yeah. And I'll tell you, this to me is like, this is kind of a big deal. There's two. I'll just say, they say Justice Jackson, this is Barrett writing, Justice Jackson decries an imperial executive while embracing an imperial judiciary. And that's after Justice Jackson had laid out how basically district court judges have a duty under her reading of the law to issue nationwide injunctions. There should be many more nationwide injunctions if we listen to Justice Jackson's admonition, basically, in her opinion. So it's a real fight for not just saying, hey, what you said is wrong, but it's what you said is not just what you said is wrong and I'm right, but what you said is like galactically awful and wrong. It's the end of because Justice Jackson is saying to the majority, what you're doing puts the republic in danger because of the lack of oversight then that the executive will have. That's sort of boiled down her argument. And then the majority is saying to her, you are so ignorant to the function of your argument that what you don't understand is what you're saying is really what will lead to the end of the republic. While Barrett didn't actually say that. And I'll just say her final line was, Justice Jackson would do well to heed her own admonition. Everyone from the president on down is bound by law. That goes for judges too. So
it's spicy.
That's a pretty strong, that's a pretty strong comeback for justice. Let's again, talk. Signed by 5 other members of the court, including the Chief Justice of the United States. And I checked just to be sure. She did articulate that section of her opinion with a different section number, so that again, it would have been so easy for any justice to say, I concur with the majority, with the exception of, section 4, but none of them did. They all signed on to the drubbing back of, because I think they were probably all insulted by her insults of them.
Well, I think the majority probably had it right on this, didn't they? Because we've just seen in recent days, we saw the No Kings march it's claiming that Trump is acting like a king. Well, it seems to me that if a single person in a courtroom somewhere can upend the entire process of what's happening in the country, then it's multiple little kings, isn't it?
That's what their argument is. My libertarian nature has me always skeptical of the power to limit the power of the executive, which is at the tip of the spear, whether it's the Trump administration or the Biden administration or Obama or Bush or anybody else. They're at the tip of the spear of violating the rights of Americans. Sure. And so it's a little trepidatious for me anytime I hear of a restriction in the right to kind of potentially dial back executive action, because legislative action is sort of more glacial, I guess you'd call it, rather than like out there actively violating people's rights, which I want the protection from. But at the same time, it's not like Congress passed this law that gave them the power. Part of the lengthy opinion from the majority examined where these powers come from. It's not just like, well, courts can check the executive so they can do whatever they want to enact that check. And the truth is, it has been abused. So why wouldn't we expect, there to be pushback? One of the things that we talked about, that chart that the Harvard Law Review published about the injunctions,
number of universe injunctions,
and recent presidents. One of the interesting statistics they teased out with that, Mark, is the percentage of those injunctions that were issued by a judge who was nominated by a president of the opposite party. And guess what? It's about 50-50, okay, until Biden and Trump. And for Biden, it was 100% of judges from the other party. And for Trump, it was 92%. So of his 64, 59 of those. And so I think that plays into the partisanship too, where it's like, well, even if there were more injunctions, but they were, 50 to 60%, you could even go up to high 60% and say that's within the margin of like randomized selection from the federal judiciary. But you're getting over 90% from the other party. Well, there's clearly something going on there, right? It's the political nature. So the combination of kind of runaway political nature of it and no clear grant of authority for these things, then I'm reluctantly agreeing with you, by the way. I don't know if you remember, but you started
I figured that.
You started this by saying the majority had it right, didn't they? And I guess I'm coming around to saying, yes, I think probably they did. But I'm skeptical about it, but yes.
Okay. We are going to find out what this means for Donald Trump and his efforts to limit birthright citizenship after this short break. Don't go anywhere. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And you're back on Liberty Nation Radio. We're concluding our talk on universal injunctions. Now, we're with Scott D. Cassenda, Liberty Nation's legal affairs editor, and he's been walking us around the garden, showing us the sites of or as Justice Ketanji Brown Jackson might say, the legalese of what has been taking place. That's a gag that only those of you who have watched the whole show will know, or listen to the whole show will get. Uh, but I want to talk about how this lifting of universal injunctions ultimately affects the presidency right now under Donald Trump, and what that means going forward for the policy agenda he's put in place. So, with the ruling coming down in Trump v. CASA, does that mean that the injunctions, the universal injunctions, the scores of universal injunctions that had been put in place were immediately lifted? Does it mean that they can the Trump administration can carry on doing what it's doing, or does it have to wait for it to go to see out a process through the appellate court? How does this work?
Yes, or the appellate courts too, depending on
Appellate
your
courts.
country of origin. So all this ruling did was establish a decision for this particular nationwide injunction that was challenged and every other one that is subsequently applied for. If it had already been applied for and granted, what a district court judge would have to do is reevaluate their granting of it given this opinion. I imagine the administration has already filed in those courts where they have active litigation and we're anticipating a nationwide injunction or are working under one, that those courts do reevaluate it in light of the court's decision here. And they will be entitled to that level of review. And then also, just like we talked about previously, what that means for further review up the chain in the appellate courts, they'll face that as well. So it's not exactly like, okay, we're going to redo all these, but practically speaking, they're going to take another look at all of them, either by themselves, sua sponte, the judges themselves will do it, or they'll entertain a review filed from one of the litigants to do it in light of this court's decision. And that happens somewhat frequently, not with this particular issue, but just that the Supreme Court makes a ruling during their term that affects ongoing litigation, and the courts are adopting then to that, new rule or standard that they have applied.
So they're beholden to the new standard because at some point, if they go against it, eventually it'll come back down with an
from
admonishment.
10 or 11 a.m. on Monday,
Sure.
June, what was it, 28th, that it came down. That's when
That's the new reality.
That's
So
the new reality. Yeah.
there's a lot of cases that have had these universal injunctions. One of them was shipping illegal immigrants to third-party countries. So now the Trump administration can continue with that as a general policy, although injunctive relief might be granted to individuals who pursue.
So any particular person may go and say, "Hey, don't let them do this to me,"
Yes.
whatever this is, and then presumably, if they have met their burden before the court for an injunction against action against them, then the court will grant. They'll say INS, DOJ, Department of State, do not molest or go after this person unless and until they've had a hearing or any number of other implements that the court might make.
So what does it mean for, and I think this is the most important question that people are considering, what does it mean for Trump's moves against birthright citizenship? Now, we did discuss this very briefly earlier, but so it's for people who are either in the country illegally or who are in the country legally, but are not resident in the country or with the proper right to remain in the country. And so because the original executive order signed on January 20, I'm just trying to get this right. It said within 30 days after this order, anybody born in the United States who is not, does not have a legal right the parents don't have a legal right to be here, or any of the other
will
conditions
not be made a citizen.
Will not be made a citizen. So, as it stands today, at time of recording, there are now people who were born in America who are not considered citizens of the United States.
Well, I got the date wrong, actually. It wasn't the 28th that ruling came down. It was the 27th. And
27th.
The day of that ruling, the court said they were going to give 30 days, I think, for the lower courts to kind of work through these issues. And I guess also the administration would then take 30 days to kind of think about how they're going to implement it and what that means for, all the people who process births in this country. It's not like we have a central federal birth registry that
that's so strange that you don't have that.
Yeah, well, it's not because of how we came about as being these states being co-sovereign. And, we're now, ever since the Civil War, we've been marching ahead towards a kind of unity, a unitary, the states are becoming more like counties, I think, rather than like independent sovereigns, which is, of course, what they were when the country started. And some of us have opinions about that and what it means for liberty and wanting to get closer to that and devolve power from the federal government. But we're getting closer and closer to that federal registry every year. But in any case, it's a dispersed, field. And how do you get different actors to act and do what they have to do? Like right now, whatever has to be done for a person to be a U.S. citizen when they're born is pretty much nothing.
Yes.
They, if they ever want to establish that they are a citizen, they show their state-issued birth certificate. So I was born in the Commonwealth of Pennsylvania. I have a Pennsylvania birth certificate. If I need to establish that I'm a U.S. citizen, I can show my birth certificate, and that's all that's needed. Even at a federal office, they take the state identity document. Now I don't know what they're going to do. If you're born in 2025 in Pennsylvania, and Pennsylvania gives you a birth certificate, it's not like if you're from, if you're spending the summer in, I don't know why you'd spend the summer in Pennsylvania if you were like a jet setter, but maybe there's a nice lake there. There's plenty of nice lakes. All right, you're spending the summer at a lake in Pennsylvania, and you're from like Turkey or somewhere, for 2 months, and you're on vacation for a couple months, and you give birth. Well, why is that person, a citizen? Well, if they have a Pennsylvania birth certificate, they're not going to get a foreign country birth certificate if that birth can't even be verified because they're out of the country. These births are verified locally. How does the administration then present the federal government? How do they deal with whether or not this person's a citizen or not? Because it's not like hospitals check citizen papers. So then we have to establish, are the parents citizens or not? Do they have permission to be here or not? It's kind of a, that it's making that hash out is no joke.
Yeah. It's definitely, it's an administrative challenge that there are so many strings to consider that I feel that each string will have a legal challenge attached to it.
Oh yeah.
So this
your children will be talking about this if they follow the news, the business of the Supreme Court, because you're right, every issue and then every sub issue, and they'll all go through up to the Supreme Court. Like we're going to be hearing about these cases for years, Mark, at least a decade, before they fine tune, because they don't have all these issues that they lock in. Like, okay, this sub issue, and kind of try to clean up all the issues with one decision. That's not how it works. It's the broad case. We're still fighting about how many years has it been since DC v. Heller with the gun control? We're still cleaning up what it means to be able to keep and bear arms in this country.
It's going to be a full employment worksheet for lawyers in the United States.
Hey, cheers to that.
Scott Cosenza, thanks ever so much for joining us today.
Thank you, Mark.
And that's all we have time for on this week's edition of Liberty Nation Radio, heard coast to coast on the Radio America Network. I've been your host, Mark Angelides. Special thank you to our guest today, Liberty Nation's legal affairs editor, Scott D. Cosenza. And of course, thanks to you, the listeners at home, for taking the time each and every week to tune in on the radio and join us. You are appreciated. Please do remember, everyone, Liberty Nation does not endorse candidates, campaigns, or legislation. And this presentation is no endorsement. Thanks for being here. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.